Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Ladies and gentlemen, this is Tice Madox Solicitors, your usual regular host, Justice Maduforo. Today, it's a very beautiful sunny day, as you can see. I thought it's a good idea to come to the sun because the sun speaks of life, basically. So I thought it's a good, interesting thing to discuss this under the sun today because I'm enjoying the sun. And with that joy, I'll be able to come to you and deliver what I want to discuss to you about today. Tice Madox Solicitors, as you know, is the best firm in London, in the United Kingdom, to guide you in all your legal matters. Legal matters ranging from those of you who need a solicitor in criminal, employment, immigration, contracts law, family law, and with general advice that you think a lawyer will have a legal input to what you're going through, then I think you guess is right, which is Tice Madox Solicitors. So this program, I have anchored this program for a number of years. That's why I will signpost you to our YouTube page, Tice Madox Solicitors, so you can catch all the programs we've discussed there. Now, that draws me to the point that whatever I discuss on this show, on this program, they are not legal advice, but really, they are only to kickstart your consciousness, to awaken your consciousness, to take legal advice. And at that point, you can now contact us with the telephone numbers on the screen, or you can send this number to your friends and neighbors that need legal advice, that you know they need some legal advice, quality one, not just seeing any solicitor, seeing a quality one for that matter. So today, I will be talking on employment matter. And my topic today will be procedures. Employment law, I'll be talking on procedures. And my procedures here, and I guess this topic is for both employees and employers, because these are the two people that are involved in employment matters, the employer and employee. I'll be talking on procedures. Now, as simple as it sounds, a lot of people miss it, especially the employers. Employment matters are kick-started with procedures. Employment matter is won or lost on procedures. The procedure you apply is either be tested or foolproof, or it is actually porous to the extent that if the court applying the legal lens will fault your procedure, and once your procedure is faulted, then if you are the employer on the other side, then you're losing. If you're the employee on the other side, you're losing. So both parties are applying the procedures appropriately and the right manner. Tice Madox Solicitors, listen to me, ladies and gentlemen. What we do as a firm is not just to jump into the employment tribunal to start representing you. The success you win or you lose, or the success you achieve or you don't achieve, starts from the legal advice in preparation. And the preparation is the procedures you are applying. And a lot of cases in the employment tribunal, if some of you are conversant with employment tribunal matters, you could see that it goes on unfair dismissal, it goes on discrimination, either marital, sex, whatever it is, disability, or religion, whatever discrimination that it comes on. It boils down again on procedure, or whether it is on breach of contracts, or whether it is on breach of notice, or whether it's breach of or failing to give payslip or give contract of employment, or of deduction of wages, or lawful deduction of wages, or constructive dismissal, or racial discrimination, whichever thing you call it in employment palace, it comes down to one thing and funnels down to one thing: procedures. And because some people are laissez-faire, some people don't pay attention to it. You know why? Let me tell you. It's because in employment environment, emotions run very high. And when emotions run very high, it beclouds judgment, it beclouds procedure. And then when emotions run high, then ego comes in, clash of personalities come in. And one clash of personalities are involved in employment matters, or ego come in within parties in employment matters. They set aside procedures, they overlook procedures, and then they're running on a high emotion, making quick decisions, making quick unlawful decisions, making harsh decisions, making temperamental decisions, and to some extent making ridiculous and very much bizarre decisions. I've seen that all. And so I offer to employees and employers alike that once any matter you have thought about in employment circumstance, seek legal advice. The legal advice will help you to maintain your cool, even gather evidence, ladies and gentlemen. Because some of you have the opportunity to gather evidence, but because your emotion runs so high, even employers that are also financially stable, okay, to have employment solicitors, contract employment solicitors to advise them and advise their human resources department. They don't do that. Some of the human resources departments are absolutely just like an employee who doesn't know the right and left and the descriptions of the job. So they don't know. Even at times, I've also been able to cross-examine human resources managers in a very big multinational and national companies and local companies. You can see the human resources personnel don't even understand their role. And once a dispute comes in place of work, the employer acting through the human resources manager or line manager or supervisor, whichever way it is that dealing with employee, are completely naive, if not even naive, are completely overshadowed by emotion, personality clash. Sometimes they do that in the interest, according to them, the interest to protect the company. But in protecting the company, they're exposing the company. In exposing the company is also losing. Because when the company is dragged to employment tribunal and it runs for 6-day trial, 1-week trial, 2 weeks trial, the company is losing a lot of money because all the personnel are in court giving evidence. This topic I'm discussing today is fundamental, is germane, is crucial, is very vital to you employee, to you employer, to find a way because, listen, I as a solicitor will want to run your case all through. But because I know how to lay a foundation to succeed in your case, because the reason why we lay foundation is what I call in any event. I put that word, in any event, which means we want to succeed here, save you expense, save you money, by dealing with the foundation and the fundamental things, save you a lot of stress, money. When we're able to achieve that for you, then you know that you're already going on path of success. What we will only be doing is for them to push in on the other party to be proving the case. Because we lay the foundation, ladies and gentlemen. We lay the foundation for you. And that is why this topic goes for employer and employee. Which means that when you lay your case properly well, you achieve the success. That brings me to the point. What are the procedures I'm talking about? Yes, you may ask me, Justice, what's the procedures? Now, procedures in employment matters start from a complaint by employee to the employer, complain about either staff, either external provider, either customers, either the manager, either the CEO, either the regional manager, whoever it is. It starts with a complaint and as minor as, cleaning the kitchen, for instance, the spiral out of control. Because a lot of workplaces use common toilet or common kitchen. Now, there was some bizarre complaints that are spiral to the point whereby employer is, running helter-skelter to organize payment and give response or defense to the claim. Now, when you are faced with such situation, you only need to just simple pause. Tice Madox Solicitors, this is a complaint we have. How do we handle it? Then I will walk you through. Tice Madox Solicitors will walk you through in such a way that you can handle that perfectly well without any problem. In such a way that you can handle the situation nicely, calmly, and with very positive result for the good of your customer, good of your employee, whether your employee is an agency worker, whether your employee is a part-time worker, whether your employee is a consultant, is irrelevant when it comes to work environment. Work environment means you're an employer and certain responsibilities you carry. So it comes with a complaint. How do you manage a complaint? Second part, the complaint may come from your employee. It may come from the employer. If it comes from the employer, that comes to what is called disciplinary procedure. When the disciplinary procedure has been instituted against an employee. Now, that's very fundamental. Now, what is the procedure? Some of you start from the meeting. Some of you don't understand because of time, because it takes a lot of time to prepare this, You have to give in written complaint or written request or written reason why you want a meeting with the employee. And then after the meeting, you have notes of meeting and documented as well. Pass over to the employee to cross-check and make sure the notes are reflective of the meeting and the points discussed. And then afterwards, the decision is made, written in a proper format, to giving the employee opportunity to appeal. Now, again, this is on the part of a disciplinary procedure kick-started or initiated or commenced by the employer as a result of misconduct, alleged misconduct of the employee or alleged gross misconduct of the employee, which could result in different outcomes. The outcomes ranging with oral warning to written warning to, as you know, to dismissal. Either dismissal, outright dismissal, or in lieu. So some of you don't know when to dismiss in lieu, when to dismiss outrightly. So there are circumstances that kickstart a dismissal in lieu. There are also the circumstances that kickstart a dismissal instantly. But you need to understand them, because if you apply the other one opposite, then obviously the employee may want to take action in the tribunal to kickstart to show that he's been or she has been unfairly dismissed. Now, that brings to the point, what is unfair dismissal? Because it tends to be the usual thing going on now in the climate. I say that in circumspect because of the Brexit period that we are in. The Brexit period has presented a lot of challenge to businesses. Some businesses are closing, some businesses are folding up, some businesses are not seeing a lot of prospects in terms of their continuous operation in the United Kingdom. So a lot of changes are happening, and those changes will affect employees. Those changes are also, a lot of it, companies are folding, are going to administration, and even when they go into administration, they must consult this meeting. These meetings must take place. So that's why I said unfair dismissal seems to be one of the commonly litigated reasons and grounds. That doesn't mean that discrimination doesn't come in. Doesn't mean that constructive dismissal doesn't come in. That doesn't mean that breach of contract doesn't come in. All these things come in employment tribunal matters, on employment matters. But unfair dismissals come to be more. And because unfair dismissal had to deal with procedures more. The procedure applied by the employer, the procedure applied by the employee. If a procedure has been applied wrongly, rightly by the employer, and the employee refuses to accept to come back to work, and rather commences employment tribunal claim, I guess you know the outcome. Because some of you don't know when you are being recalled back to work. Maybe the first decision of your complaint has been dealt in such a way against you, or the first decision of the employer's disciplinary procedure against you has gone contrary or adverse to you. And then in subsequent to that, then what happened now onwards is that the employer will review that decision by your appeal and will either uphold the first decision or disallow the first decision, which means holding you that you are not entitled to return back to work, assuming the first decision, dismissed you. Now, if you holding on to emotion at that point and decide to run on the fact that you won't return back again, and then obviously you have not been dismissed. So your employment claim will obviously fall down. Unfortunately for you, the employment tribunal may proceed with your case until the other party flags up that error. If that error is not flagged up, your claim will continue. But if it's flagged up, that means that you almost as good as bad as your appeal. So, ladies and gentlemen, procedures are crucial, especially in this dire position we are now. Businesses are going to administration, more especially, and the Brexit is not helping matters. Now, not just businesses as well. The policies of the government are also not assisting. The government are ruling quite a lot of policies. Recently, there were policy for anything employment claim to pay certain fee, claim fee, hearing fee, which amount to thousands. and these are employees who have been sacked or lost their job. So along the line, the reason behind the decision may be justified. The reason that the court want to, chalk out and take away spurious claims, vexatious claims, malicious claims, and so that only those genuine will proceed. That is a good idea. But obviously it falls flat in the sense that it may not be in the good interest of access to justice without be. Now, recently the court changed that and adjourned that it was wrong. So therefore, hearing fees collapse. Now, this is one of the policies of the government that may apply and affect employment. Now, it is restated back. Now, it's obviously free to lodge your claim in the tribunal. But the question now is that if you lodge in the tribunal, what is the I'll put it this way, what is the claim? Is the claim worth it? Is it actionable? Or is it just to drag your employer to the employment tribunal? And if you lose and you don't get paid, you don't get to pay the cost. Obviously, in certain circumstances, the court will order you to make cost, because costs have to be paid if the claim is vexatious, if the claim is absolutely malicious, if the claim was groundless and baseless, and so it was brought to be litigated. The Tice Madox Solicitors, what we do is to sip out those ones from the beginning. When we found out that the claim is vexatious and the claim is absolutely, outrightly ridiculous not to proceed, we'll advise you, the employer. If your claim is not good, employee, we'll advise you, employee, and say this claim is not good, this claim is not strong. If you want to run with it, look at what you will expect. That is subject to you to continue to run. But we will do that on the basis that we have already looked at the procedures that has been applied. The procedures may have been applied in the right way, but the outcome was questionable. The outcome was gross. The outcome of that procedure applied was absolutely disproportionate, not appropriate in any spheres, in any reasonable court, litigating and listening and applying discretion will know that that decision taken was not the right decision. Ladies and gentlemen, what Tice Madox Solicitors would do is to unravel the procedures and pick out the errors in those procedures. So you, the employee, you are going through that right now. Obviously, I can tell you very well, without even saying anything, not everybody, this has been gone and paraded several times, not every half of employees in every existing establishment on employment are one way or the other not happy with employment. But not happy with employment is different from when the employer has done anything wrong. So, but for instance, as a result of certain complaints or things that you're going through your employment, some employees tend to be disgruntled. And some people say looking for trouble here and there and how to kickstart a claim. In that circumstances, you, the employer, will want to make sure that you're not dragged further and you shut it down as quickly as you can. Seeking advice at every point in time, you, the employer, is important. Seeking proper legal advice. Sometimes your HR departments are not up to task, which is why some good companies outsource their HR departments, which means when a claim starts or a complaint starts, they seek advice straight up first from the solicitors, and they're able to guide them on the right thing to do, on the right step to take, on the right procedure to commence. When those steps are taken, you are on the right path. Your employer will not have any problem because you'll be on the great path. Even if the employer continues to drag the case further, you will know that success is guaranteed because you've taken all the steps necessary and prescribed by law for you to take, ladies and gentlemen. So it's important that you don't make mistakes about this. Procedures are crucial. Somebody may say, okay, does it apply only in employment matters? Of course not. Procedures apply in criminal matters. If there are a lot of issues in criminal proceedings and the prosecution failed to apply or to disclose certain things required that will go against them, so they have breached the procedure because they are under the obligation of the law to disclose what is for and against them. Then that's procedure. Some cases are reopened because certain things were not disclosed. And when it discloses, it affects this case. When if was disclosed, affects the merit of the case. Where disclosed, affects the chances of the case, both for the defendant and the prosecution. Now, in employment matters, the procedures are important. It may affect you, the employer. It may affect you, the employee. because it creates the balance whereby each party will understand their case, will see whether it's actionable or not. Now, in certain circumstances as well, as I said, procedure is important. Your case may not even go to the tribunal because it will be finalized at the early stage, either by way of a compromise. Obviously, compromise agreements are not done when there are criminal matters involved, but compromise agreements to deal with matters and to settle the matter even before a tribunal claim is issued. Not only is this saving you a lot of cost, you the employer, also the employee. Because employee, obviously you got to get your representative, depending on whether your case is good or not. Now, by the way, that brings me to, in terms of funding, this company will fund your employment cases where your case is good. We will discuss on conditional fee arrangement, which is no win, no fee basis to the extent, and to see that your case is good. We can run that with you. You can also fund your employment tribunal cases or employment claim cases through your insurance. You can purchase insurance to do that. Sometimes if you are a house owner or a landlord, or you are a house buyer or house owner, you can have from legal services insurance or legal services protection imputed in your mortgage. So you could see that you would not even need to pay. It's about going to your mortgage and see what is prescribed, what is covered, or what is not covered. Now, give you an instance now. Some of you own vehicles and you purchase vehicle insurance. Some of vehicle insurances protect you from windscreen damage. It protects you from third-party damage. It protects you from any other, courtesy car, for instance. It protects you to a lot of things, even legal services. It protects you there. This one purchase. So the same thing applies to mortgages. When you purchase, has content insurance, in your mortgage to protect your mortgage, protect your property from fire and the rest. Some of them are imputed there. Legal services are all there. And in that legal services, it prescribes what is covered or not. It only cover employment because it is crucial, because it normally contains employment, because if you lose your accommodation, your employment, you can't sustain paying your mortgage. So that comes in there to protect you. So you got to look at that. If you covered on that, you're not paying anything. Your insurance will be contacted. Your insurance will look at your case. Your insurance will see the merit of your case. Your insurance will now decide to approve it and fund it, ladies and gentlemen. Sometimes your insurance may fund it for one case per year or 2 cases per year, depending on what you have already done. So, ladies and gentlemen, coming back to the issue of procedures, complaint raised, complaint dealt with properly, avoids unfair dismissal claim. Complaint raised, complaint dealt properly, avoids constructive dismissal claim. Complaints raised, complaint dealt properly, and decision made disproportionately avoids discriminatory claim. Complaint made and decision made properly and procedure followed properly will avoid any other claim, contract breaches claim. That's just what this program is all about. This is not a legal advice program. And as I did say to you, ladies and gentlemen, do not act on what I say on this program, but rather come to the office. Telephone numbers are displayed on the screen. You can't say you don't have the numbers. The numbers on the screen, the addresses on the screen, social media handles on the screen, Instagram is on the screen, Twitter is on the screen, Facebook is on the screen. Ladies and gentlemen, you have no, YouTube is there for you, so that you can catch up this program if you miss part of it and go back to YouTube and listen to it again. And you see the passion with which I explain things to you. I draw your attention to see that one firm, only one firm, can assist you in cost-effective matter and success guaranteed matter, or success and fairness procedures. So this is my offer to you, that you take advantage of this program and that you contact other people of going through employment matters. Either you're already in the tribunal already, or you're about to go to tribunal, or you're facing disciplinary proceeding. Ladies and gentlemen, if you're facing disciplinary proceeding, pause. Don't go into that meeting. That is the foundation of your case stands or fall. That is it. If you go in there or you go admitting certain offenses, your case is as good as it is or as bad as it is, ladies and gentlemen. So therefore, you must pause. You, the employee, going into disciplinary meeting, return back, seek proper legal advice from Tice Madox Solicitors. We'll guide you properly, and your case will succeed. When you go to that tribunal meeting or that disciplinary meeting, you go with confidence. Your defenses is provided. Success is guaranteed. Ladies and gentlemen, I've been talking on employment procedures. And I guess that you must have picked one or two things necessary. You, the employer, you, the employees, to kickstart your consciousness. We cover other areas of law, and it's been a pleasure anchoring and discussing this with you today. But however, If you feel that you still need us to go deeper into your case, call us on the telephone. Come to the office. It's a friendly place. We will stay on the issues, advise you on the issues. You work out solidly comfortable that you know the issues and you know what your case is worth, what your case will cost, what your case will take, how long case will take. Any stress associated with your case, we will relieve it from you because we are in it. We are guiding you along the way so you will not be stressed. You will not in any way find any cause to be worried. Ladies and gentlemen, it's been a pleasure. I remain Justice Maduforo, your favorite solicitor, on this program, Tice Madox Solicitors. God bless you.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional,